Good morning. Are you Janetta Pugh?
I am the beneficiary of that estate.
You're the what?
I am the beneficiary of that estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand.
Beneficiary of that estate.
Okay. What's the announcement?
Judge, it's my understanding that Ms. Pugh and her family has retained an attorney on this matter. You may, I don't know if you remember, Judge, this one I was originally appointed on, and we were on the trial docket. She hired a new attorney at that point. Mr. Norwood, who was on the case for a while and then withdrew. And once recently, when the case came back to me, I visited her and was told that they did retain another attorney. I was given the name of Christopher Wiley this morning, but I have not heard from him. And my understanding is that at this point still hasn't filed anything with the court.
Okay.
But I've been told that that's who's supposed to be taking over the case.
Okay.
Notice what's happening here. Before the court can discuss evidence, defenses, or even trial dates, it has to answer a much simpler question. Who is actually representing the defendant? Criminal courts run on procedure, and when nobody can identify a valid attorney on record, everything else comes to a halt. That's why the judge is digging into this issue first.
For the record, I recognize Ms. Pugh. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pugh's behalf.
All right. So, Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact.
This is where the hearing takes a sharp turn. The defendant is relying on a theory commonly seen in sovereign citizen circles, that public defenders somehow work for the state instead of the client. But legally, that's not how it works. Court-appointed attorneys owe their professional duty to the defendant. The judge now narrows the situation down to 3 real choices: accept counsel, hire counsel, or represent yourself.
The court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, 2 things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself, or are you going to let Mr. Lewis represent you, or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it, and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
That answer may sound simple, but it's legally devastating to the argument being made. The defendant is asking where the claim against her exists. The judge points directly to the indictment, the formal document that starts a felony prosecution. In other words, the court isn't guessing why she's there. The charges have already been reviewed, filed, and presented through the legal process.
I've received your petition for writ of habeas corpus, and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel to effective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
So here's the thing, Miss Pugh. I appreciate your position, but listen,
Respectfully, Your Honor,
Miss Pugh,
with
don't
my
speak over me.
incarceration- Respectfully, Your Honor, with my incarceration being
Miss
so-
Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on, listen.
This is the moment the hearing stops being about legal arguments and starts being about courtroom control. Repeating the word respectfully doesn't give someone permission to interrupt a judge. In fact, every interruption weakens credibility. Watch what the judge does here. He doesn't argue, he doesn't get emotional, he simply keeps returning to the same point. The rules apply whether you agree with them or not. And by the end of the hearing, the outcome hasn't changed at all. Keep the lawyer, hire a new one, or represent yourself.
To me, everything you have there is overruled. And here's one of the reasons why, is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
I do not agree or comply to your appointed.
Go back.
Agents.
You already said that, and that's overruled.
Duty is to the state.
Go back with the bailiff. Get your own attorney or represent yourself if you don't like it.